Good afternoon. Welcome to Assembly Natural Resources. Madam Secretary, please take the roll.
Assemblywoman Anderson. Assemblywoman Bilbray Axelrod. Assemblywoman Brown May. Assemblywoman Considine. Assemblyman DeLong.
Present.
Assemblywoman Duran. Assemblyman Gurr. Assemblywoman Hanson. Assemblywoman LaRue Hatch. Assemblyman Watts. Assemblyman Urick. Chair Cohen.
And I am present. Again, welcome to Assembly Natural Resources. We have 3 bills on a work session, and then we will take public comment. We are going to go out of order because we do have one senator who is present and one senator who is in a work session. So with that, let's begin with Senate Bill 258. Ms. Pratt, if you'll go ahead with that.
Thank you, Chair. For the record, Becky Peratt, Committee Policy Analyst. Senate Bill 258 provides that the state engineer may grant a temporary change of the place of diversion, manner of use, or place of use of water already appropriated for a period of more than 1 year, but not to exceed 3 years, if the temporary change is for a renewable energy generation project. There are no amendments to this measure.
Committee, do we have any questions? Okay, seeing none, I will take a motion to do pass.
So moved.
Okay, I have a motion from the vice chair and a second from Assemblymember Bilbray Axelrod. Any comments? Seeing none, all those in favor, please say aye. Aye. Opposed, nay? Okay, that passes unanimously. And I will give the floor statement to Assemblymember Hanson. And Ms. Pratt, let's go on to 269.
Senate Bill 269 prohibits a person from restraining a dog outdoors during any time in which a heat advisory, excessive heat warning, wind chill warning, or winter storm warning has been issued for the area by the National Weather Service. The bill also eliminates certain exceptions from restraint and outdoor enclosure requirements for dogs being used or trained to hunt, and for dogs temporarily being cared for as part of a rescue operation or in conjunction with a bona fide nonprofit organization formed for animal welfare purposes. Finally, the bill adds exceptions to the restraint and outdoor enclosure requirements for a dog being processed into a shelter or under the direct custody of a person engaged in a temporary task or activity with the dog for not more than 1 hour, provided a heat advisory, excessive heat warning, wind chill warning, or winter storm warning has not been issued for the area. Senator Orenshaw proposed an amendment, attached for the committee's review. To summarize, the amendment removes the prohibition against restraining a dog outdoors during certain weather warnings issued by the National Weather Service, decreases the time period that a dog can be restrained outdoors from 14 hours to 10 hours during a 24-hour period, and reinstates, revises, and adds certain exceptions to the restraint and outdoor enclosure requirements.
Committee, are there any questions? Go ahead, Assemblywoman Bilbray Axelrod. Okay, we'll wait till after, okay. So with that, I will take a motion to amend and do pass.
So moved.
I have a motion from Assemblymember Watts. Do I have a second? I have a second from Assemblymember Brown May. Okay, so if you have a comment, please go ahead.
Sorry. Thank you, Chair. And I thank the bill sponsor for working on this. I know that the committee was concerned with some unintended consequences, such as, walking your dog, being considered tethering. So I appreciate the work on this. I just did want to get on the record one thing. I'm a huge animal lover. I love my dog. I can't imagine ever having to deal with any of these things, but when it comes to the weather service, I just really do feel like that's a county issue, and I know Clark County has very stringent things, so and that's why I was kind of iffy on the bill, but with the amendment, I'm very happy to support it. Thank you.
Thank you. I also have a comment from Assemblymember Urick.
Yes, thank you, Chair. I also want to acknowledge, I think, just the great intention of this bill and truly the senator's willingness to work and amend various provisions of this bill to accomplish a piece of legislation I think is much more palatable. However, I still remain concerned with the issue that I brought forward at the hearing, and that is in a state, and in particularly down south, where there are 10 and 12-hour shifts, the reduction of the 14 to the 10 hours I think creates still problems for too many people. And so it is based on that provision of this bill alone that I will have to go no today.
Okay, do we have any other, go ahead, Assemblywoman Duran.
Thank you, and I appreciate as well as the amendments, but I will still have to research. I am going to vote it out of committee today, but I do reserve my right to change. Thank you.
Thank you. And as a reminder, committee, especially as we're going to be spending a lot of time on the floor, all members have the ability to change your vote. We do just ask if you are going to change the vote that you give us the courtesy of informing the bill sponsor and the chair in all committees. Okay, so seeing no other comments, all those in favor, please say aye. Aye. Okay, opposed, nay? Okay, so will the nays please raise your hand? So I have a nay from Assemblymember Hanson, Urick, Gurr. Are you? Okay, all right, thank you. So Hanson, Urick, and Gurr. Okay, thank you. With that, it does pass as amended, and I will give the floor assignment to Assemblymember Bill Axelrod. Thank you. Okay, so with that, we will go on to Senate Bill 76, and we do have the bill sponsor here, so I know there's a question, but we'll go forward and then we'll have our question.
Senate Bill 76, amongst other things, prohibits the sale and distribution of certain products containing intentionally added PFAS and requires a manufacturer of cookware containing intentionally added PFAS to include certain information on the product label and on any product listing for online sales. There is one amendment attached to the work session document, which, amongst other things, removes the requirement for manufacturers of certain products to include a label specifying the product does not contain intentionally added PFAS, revises the labeling requirements for manufacturers of cookware that contains intentionally added PFAS, provides that a violation of the requirements of this bill is a misdemeanor, and revises the effective date.
Okay, so I'm going to make a comment before we go to questions. Senator, I appreciate the work you've done on this bill. I think you did try to work with the stakeholders and the opposition, and I think to the point past where you probably, I think a lot of members were willing to get the bill out of the committee a long time ago, let's say, before a lot of the changes that you were willing to make to try to accommodate the opposition. But with that, I will let any members who have questions, do you want to go ahead and ask your question? Go ahead.
Thank you, Chair, and thank you, Senator, for coming. I appreciate you being here. In the amendment, you added, there's amendment number 7, which adds a new section 5.5, which wasn't in there before, about a penalty. I was wondering why that was added.
Thank you for the question, Assemblyman DeLong. So currently, under statute, if you pull this up, NRS 202.220, which we currently have a miscellaneous provisions in law for crimes against public health and safety, where there actually is a misdemeanor language for circulating materials of prohibited materials, right? And so when we were looking at, okay, it can't fall under the AG. We don't have an actual specific agency that handles PFAS, right? The idea was to take the language that was in statute under the Crimes Against Public Health and Safety, which Clearly, there's a misdemeanor for circulating a publication which is prohibited material, which could be associated with a health issue. It seemed like if that was the standard, then why not have a misdemeanor as well for PFAS, where we have a dangerous chemical actually applied to a product? And in this case, a misdemeanor is actually a very low-level offense, but it came from existing law in our miscellaneous statutes under crimes against public health and safety.
Go ahead.
Thank you, Chair. I have a question. I don't know if it's for the sponsor or for legal, but we learned in education just last week that if a penalty is not specified, then the default is a gross misdemeanor. So this is actually saying it's lower than it would be without a penalty at all. Is that correct?
Senator Neal, for the record, that is correct. A misdemeanor is lower than a gross misdemeanor.
Okay, any other questions? Go ahead, Assemblymember Hanson.
Thank you, Chair. That just, if we could clarify that a little more. The question was, yes, it's a misdemeanor here, but if legal, if it's not stated, the default is gross misdemeanor in statutes? Or did I just hear it wrong?
Erin Sturdivant, Legislative Counsel Bureau. NRS 193.151 provides that where no penalty is specifically stated, but the performance of an act is prohibited by statute, the act is a misdemeanor.
So, Senator Neal, for the record, so if everybody, I mean, because I understand what you're thinking, but if you go to existing law, which actually has miscellaneous crimes concerning public health, which is, starts at 202-170, pretty much these particular provisions in statute have been, I would say, willfully poisoning, has been in since 67, 71, 79, 95, 97. There was a added piece on sale, distribution, purchase, and possession of powdered alcohol, which was added in 2015. And then as we go for the provision that I mentioned around the circulation of prohibited matter, that has been in law since 1967. And other than that, there have been, the latest update was 2015 into this particular chapter under miscellaneous public health concerns. And so it seemed to make sense if it's already in statute, it's already been law. One of the most recent updates in 2015 was when we had a completely, entirely run, Republican-run legislature. That was the latest update to this particular statutory provision, and a misdemeanor is the lowest piece. What I had in there before that folks had a problem with was the private right of action. The AG doesn't have enough personnel in order to investigate this. So the option was either to have nothing, right, and then wait until some future moment when we actually establish an agency, which will cost money, or to try to figure out how to give an enforcement provision when I'm giving a notice provision.
Okay, Assemblymember Hanson.
Thank you. And yes, thank you for addressing the private right of action. That was a part that was bothersome in the original form. This question may be for legal, although I know you've got a great legal background, so you might be able to answer it. When we did nicotinoids, is that how we say it? Neonicotinoids, that legislation, was there a component in there that if you knowingly or willingly were still producing or selling, was there a provision in there that there was some sort of misdemeanor? I'm just curious, the consistency.
As I recall, and that bill went over to the Senate, the producers, it had been civil. The producers actually wanted it to be, no, actually, that's not the neonicotinoid, that's the bill sponsor is my roommate, so I hear a lot about that, and the other bill that she brought having to do with feminine hygiene products. And now I think I'm getting them confused, so I will defer to Ms. Peratt.
Requesting one moment to refresh my memory on AB 162.
And in the meantime, Assemblymember DeLong, can you ask your question?
Thank you for the indulgence, Chair. Just going back to the misdemeanor issue, making it a criminal, is there a reason you didn't consider civil fines versus criminal?
Well, that came, Senator Neal, for the record, that came down to who is the enforcement agency, right? So I spent a lot of time talking to the AG, and I can pull up that conversation on, we went round and round about, okay, what are my different options to try to figure out how to deal with the language. And so, let me pull this up. So we talked about it a lot. So this is what we looked at. So in this conversation, I looked at it, there was an option to try to figure out if I could place language in NRS Chapter 41, which would allow a victim to engage their own attorneys and bring a cause of action with experts to investigate. Nobody liked that option, right? That was a private right of action. The next was language could remain in NRS Chapter 459, which was hazardous waste, and the enforcement language would then have to be removed because I had changed the chapter, remember, I took it out of 459 and I put it in the other miscellaneous provisions where we have other things. So then we talked about whether or not I should have, where was the enforcement provision for the PFAS in the firefighting foam bill that was in NRS 459-670, where there was a working group, right? We're past a working group. Then there was a conversation about whether or not I could place language in new chapter under Title 40, under Public Health and Safety, without enforcement authority until such time as the legislature wants to add enforcement authority. Why would I do that? That doesn't make sense. So then I started to look at, okay, then we looked at, well, could I look at enforcement language or a modified version of it, where then I would go into NRS Chapter 202 under Crimes Against Public Health and Safety, and that's where I pretty much landed, but I had the option to also look at NRS Chapter 207 under Miscellaneous Crimes. But because this has, PFAS has been pretty much designated as a health concern, I felt the better chapter was 202. And because there was already misdemeanor language in there, I didn't feel that I was going out of bounds of creating some new criminal penalty that didn't already exist within the NRS 202 for crimes against public health and safety. So that was my reasoning.
Okay, and if I could ask counsel to address the other question.
Erin Sturdivant, Legislative Counsel Bureau. AB 162 made it a misdemeanor to violate the provisions of the bill with respect to applying a pesticide of that type in violation of the requirements of the bill, but it doesn't include the knowingly and willful language.
Okay,
Thank you. So essentially, I'm sorry, I should have asked permission. So, thank you for that. So essentially, we did the same thing, right? With the neonicotinoids, it has this kind of a provision. It might be in a different place, but am I understanding that right? It's a misdemeanor to apply those substances or those chemicals, and we're kind of saying the same thing here.
Erin Sturdivant, Legislative Counsel Bureau. Yes, it would be a misdemeanor to apply those pesticides in violation of the requirements, and under this bill, it would also be a misdemeanor to sell or distribute items containing these chemicals in violation of the provisions of the bill.
Okay, so seeing no other questions, I will take a motion to amend and to pass. Okay, I have a motion from Assemblymember Watts and a second from Assemblymember Brown, May. Do we have any comments? Seeing none, all those in favor, please say aye. Aye. Opposed, nay. Okay, so that was unanimous. And I will assign the floor statement to the vice chair.
Thank you.
You're welcome. So with that, we will bring the work session to a close, and we will open up for public comment. Do we have anyone in Carson City for public comment? Okay, seeing none, I'm seeing no one in Las Vegas. VPS, I guess I do see someone in Las Vegas, but I don't think they're coming forward. Okay, not coming forward for public comment. Do we have anyone on the phones for public comment?
Thank you, Chair. The public line is open and working, and there are no callers at this time.
Thank you for that. Okay, so with that, we will be in recess. I do not believe we will be back in. I think we will be adjourning, but for now, we are in recess. Thank you very much.
Growth and Infrastructure Committee members, that's your cue to make it down to this room. Thank you.